I'm an attorney in private practice in the Reno-Sparks area for the past 36 years. We'll start today by talking about the guardianship of the estate. This includes managing the personal property as well as the real property of the protected person, managing their bank and brokerage accounts, as well as bill paying. A guardian of the estate is responsible for managing the protected person's assets as well as their personal finances. The court may require a bond. That is like an insurance policy that is written by a bonding company and is used to protect not only the protected person but also the guardian, and it is set in an amount determined by the court. Usually it's in an amount that is set by the liquid assets in the guardianship estate as well as perhaps 1 year's income. This protects both the ward and the guardian. In the event there is any mismanagement of assets, the bonding company is obligated to pay for any loss that occurs. Another option for the court, instead of a bond, is to have the court order provide for blocked accounts. Those are accounts that are not accessible by anybody, including the guardian, without a court order. And that is another way to protect the protected person's assets and make sure that there is court oversight. Another option for the court is in the order of appointment to order that the liquid assets in the guardianship accounts that cannot be accessed by anybody, including the guardian, without a court order. A guardian of the estate is responsible for managing the money and locating all assets that might belong to the protected person. That would include real property, personal property, bank accounts, investment accounts, and so forth. The guardian is responsible for determining all income sources as well as any debts that the protected person may have. Income sources may include retirement accounts, investment accounts, veterans benefits, Social Security benefits, and the like. A good way to determine what the protected person's assets are is to take a copy of the order of appointment and the letters of guardianship to the post office and have the protected person's mail redirected to the guardian so that you can begin to look at what monthly income and the sources thereof, as well as any debts that the protected person may have. Securing the assets and the income is the first step that the guardian of the estate takes in order to prepare the inventory, which is due within 60 days of the order of appointment. As I mentioned earlier, income sources may include veterans benefits, retirement benefits, PERS benefits, and the like. And the best way to, as I said, determine what those are is to redirect the protected person's mail. The guardian of the estate will also want to determine what insurance may be available out there. This may include life insurance, homeowners insurance, secondary health insurance benefits, HMOs, and the like. Again, this is all part of determining what the assets are in order to file the guardian of the estate's inventory. The guardian of the estate will want to determine whether or not the protected person is receiving Medicare benefits. Medicare is a federal program for persons age 65 and older. Medicare has 4 parts, Part A, B, C, and D: hospital insurance, medical insurance, and prescription insurance. To be distinguished from Medicare is Medicaid. Medicaid is also a federal program. It is designed for persons with low income, seniors, and persons with disabilities. Eligibility is based on both income and assets. Generally speaking, a person to qualify for Medicaid benefits cannot have more than $2,000 in cash assets. This excludes a family residence as well as a personal vehicle. In order to qualify for Medicaid benefits, the applicant's income and their expenses cannot exceed the minimum thresholds as established by the federal government. As I said earlier, the guardian of the estate must file an inventory within 60 days of the entry of the order of appointment. By law, it is required to set forth all of the assets of the protected person, as well as any debts they may have, as well as any other information the court may need in order to determine what the overall financial picture of the protected person is. A form for the inventory can be found on the Washoe County Court's website, as well as the milestone tracker, which sets forth all of the forms that you may need as guardian of the estate. The guardian of the estate must set up a guardianship account. It is in the protected person's name and remains with the Social Security number of that person. However, it is titled in care of the name of the guardian. The number one mistake I see in family guardianships is the commingling of funds. The guardian cannot commingle their assets with that of the protected person. Family members sometimes have managed their parents' finances for years and perhaps have deposited their Social Security checks into their accounts. This is no longer permissible if you have been appointed as guardian of the estate. As guardian of the estate, you are also going to be responsible for bill paying. Develop a traceable ledger system that sets forth all of the income that you have received on behalf of the protected person, as well as all debts that you have paid on their behalf. Keep all receipts for expenses that have been paid, and keep all canceled checks as well. As I mentioned earlier, redirecting the protected person's mail to you as the guardian can be done once the order of appointment is presented to the post office. The guardian of the estate will early on in the process be required to file a budget and care plan. This must set forth in detail all of the monthly costs of care of the protected person, as well as any sources of income. It must be filed with the court early on so the court can determine how long the protected person's assets may last for their costs of care during their lifetime. A guardian of the estate is responsible for spending only within the protected person's financial means. At the same time, under Nevada law, the guardian is not personally responsible to pay the protected person's debts. The guardian of the estate is also responsible for preparing and filing any federal tax returns on behalf of the protected person. A guardian of the estate is also responsible for managing all significant assets the protected person may have, including stocks, bonds, investment accounts, and the like. These types of investments cannot be altered or liquidated without a court order. Seek the assistance of a financial advisor. And if you have any questions about any of these types of assets, ask your attorney or look on the court's website to find a form to file a petition for instructions with the court. By getting a court order authorizing any change in these types of investments, the guardian protects his or herself. In addition to filing an inventory within 60 days of the entry of the order of appointment, the guardian of the estate is required to file an annual accounting every year. This must set forth all of the assets and all of the income that has been received during the period of the accounting, as well as any expenses that have been paid. Again, if you go to the Washoe County Courthouse website, you will see a form for the annual accounting. Unlike the inventory that is simply filed with the court, the annual accounting is also filed, but it must be set for hearing, which means that a notice of the hearing and a copy of the accounting must be sent to all interested persons and the protected person within the time parameters required by law. The guardian of the estate and the protected person must appear before the court and have the court approve the accounting. For estates of less than $10,000, there is an accounting that must be filed, but unlike estates over $10,000, it can be simply filed with the court without a hearing.